welcome to my channel. Today myself C.S. Trupti Upadhyay will take you to another lecture on company law. This lecture is specifically dedicated to the University of Calcutta students, but obviously any other university student can also watch this lecture if he or she is giving exam for the company law. Fine, and always the professional students are invited. They can also check out this video for more concept clarity. Let's see what is today's topic. Before coming to the today's topic, these are the few books. You can go through them. You can check out. This is our website of Ministry of Corporate Affairs. Here you can check out the e-book on Companies Act 2013. Today's topic is vacation of office of director. First, this section is under section 167. It is being said these are the few conditions under which the director has to vacate his office. People, first we should understand what is the difference between vacation and resignation. Vacation section is section 167. Resignation section is section 168. The meaning of the two words are different, but the result of the two words is the same. Now let us understand first the meaning of the word vacation. Vacation means that a person has to go and has to leave his office. In resignation, what happens? That willingly a person is resigning from his post. But here, if whatever are the conditions, we'll go through these conditions one by one. So if these conditions occur, under these conditions, he will be forced to vacate his office. So understood? Vacation is forceful and resignation is voluntary in nature. Fine. Now let's move to subsection 1. Office of a director shall be vacant in these cases. There are 6 cases on your screen. First case is regarding if he becomes disqualified. The director is disqualified under section 164. So under 164, if there are few conditions under which if these conditions occur, any of these conditions occur, he will be attracting the disqualification. Fine. But where the disqualification is with respect to subsection 2 of section 164, then the office of the director shall become vacant in all the companies other than the company in which the default has occurred. Right? This line is given over here as well, and these lines are the same lines which are being provided under 164 subsection 2 as well. So whoever is the defaulting company under 164 subsection 2, in there these directors will be staying, but their directorship they have to vacate their offices from other places where he was director. Suppose company A is a default company in which the default has occurred. Then in company A, Mr. A director can stay, but Mr. A director is suppose a director in some other company other than company A. Then in all the other companies he has to vacate his office because now he is a disqualified director as per section 164 subsection 2. Next, if he absents himself from all the meetings of the board of directors during a period of 12 months, with or without asking for leave of absence. So if a director do not attend any of the meeting, we know that at least 4 board meetings need to be there in 1 year. Every quarter 1 meeting is compulsory by the provisions of Companies Act. So if a director is not attending any of the meetings, whether he has taken leave of absence or not, leave of absence is not granted or not taken, doesn't matter, he has to leave his place, that is vacate his office. If the director contravenes any of the provisions of section 184, then also he has to vacate his office. Section 184 basically speaks about the disclosure of the interest, whether directly or indirectly a director is interested in any contract or arrangement. Then he has to specifically convey the message that I am interested to the company beforehand. So if he doesn't do it, then he is contravening the provisions of 184. He fails to disclose his interest. That only is written under 184. Next, he became disqualified by an order of a court or a tribunal. If a court or a tribunal has disqualified him, suppose disqualified a director, disqualified a person for becoming a director for next 2 years, and if the order is in force, he has to vacate his office. He is convicted by a court of any offence, whether involving moral turpitude or otherwise, and is sentenced in respect thereof for an imprisonment for not less than 6 months. So he was convicted by a court of India, court of our country, whether the offence was involving some moral turpitude, means that some morally it was morally affecting the society at large, right? This kind of crimes, example rape or any other murder or anything, whether involving moral turpitude or not, and he is also been found guilty and sentenced for imprisonment for minimum 6 months. Then what happens? He has to vacate his office. But when this, suppose he is being imprisoned, he is being convicted and he is being sentenced for an imprisonment of 5 years, 10 years, then obviously we know that in our legal system, we have, if a lower court has given you a punishment, you can always go to the higher court for an appeal. So here is written that provided that the office shall not be vacant, office will not be vacant by a director in case of the orders referred to in clauses E and F. E and F is the order of the tribunal and also the order convicting a person for a punishment, imprisonment for more than 6 months for an offence. So these two cases, in these two cases, if you have appealed, you have within 30 days from the date of order convicting you have appealed to the higher court, then you can still stay in the company. Your office will not be vacated. Till how much time you can stay? Till the time the appeal is being disposed of and the resulting order is there. From that order, within 7 months time is given for further appeal. So you appeal again if it is against, if the order comes against, it's a order which is coming against, then obviously this person has also a chance to again appeal. Further appeal should be done within 7 days. So still he will be continuing as a director, not vacating the office till this appeal is being disposed of. After the result of the next appeal comes, that is the further appeal, then obviously we will see that whether he is being convicted or acquitted. He is acquitted, then he'll stay with us in the company, and if it is convicted, then obviously he has to vacate his office. So this is the provision. If he is removed in pursuance of the act, removal section is section 169. So we will be covering section 169, the process of removal, how he is removed, who can remove him from the directorship, in a separate lecture. Next one, he having been appointed as a director by virtue of his holding any office or employment in the holding subsidiary or associate company, and ceases to hold such office. Means suppose he became a director in the company A because he was a CEO of company B. Company B is a subsidiary of company A, and suppose he has left the position of CEO of company B, then why he should be appointed as a director of company A? So that is only written. Fine. Next, coming to subsection 2. These were the few cases earlier we have discussed under subsection 1 in which the position of office of the director has to vacate his office. Now we will be learning about the penal provisions, that if he doesn't obey the rules which are given under subsection 1, what will happen? If he still functions as a director, even if he knows that his office is already has to vacate his office, then he is punishable with imprisonment for a term which may extend to 1 year, or with fine which shall not be less than 1 lakh rupees but which may extend to 5 lakh rupees, or both the things can be imposed on him, imprisonment and fine. Fine. Suppose if all the directors of the company has to vacate his office because they have attracted the provisions of subsection 1, any of the conditions, right, and no director is now present in the company to maintain the affairs of the company, manage the affairs of the company, then the promoter has to come. Promoter, or in the absence of promoter, the central government will intervene and they will appoint the required number of directors. We already know that for public company minimum directors are 3 and for private company minimum directors are 2. So minimum directors will be appointed either by the promoter if promoter is there, or in his absence by the central government. Till these directors will work till the directors are officially appointed by the company, by the shareholders in the general meeting. Apart from this, which we have learned, private company through the articles can impose any other ground. We know that in subsection 1 few grounds are mentioned, we have already discussed, but apart from that any other condition can also be laid down in the articles of the private company, and private company can impose these conditions on the directors. Fine. So we'll take our lecture is now towards our end. So thank you all. Hope you like this lecture. If you like this lecture, please kindly motivate us by sharing this video to your friends who will also be feeling helpful, it will be helpful for them as well. So thank you all.